They had met Martha Moxley. One of them, Adolf Hasbrook, had become obsessed with her, that they plotted the murder on the way up that night. They confessed to the murder on many, many occasions thereafter, and that the 11-year-old boy in whose home they cleaned up also corroborated their confessions and said that indeed they had stayed the night and cleaned off the blood in his house. So, and there's lots and lots of corroborative evidence. Again, it's outlined in the book, and I don't think that that people who read the book will have any question that these two gentlemen killed Martha Moxley.
That's Robert F. Kennedy Jr. earlier this year talking to me about the case against his cousin Michael Skakel. The Connecticut Supreme Court just reinstated Skakel's murder conviction, overruling a lower court that released him from prison in 2013. Now, he'd been held for a decade since the jury found him guilty in the 2002 conviction. Skakel, as you remember, convicted of killing his Greenwich neighbor, Martha Moxley, in 1975 when both were 15 years of age. He got a 20-year to life sentence many years later. In his book called Framed, Kennedy Jr. says the police investigation was botched, there's prosecutorial misconduct, and two Bronx teenagers, he argues, committed the murder. Now, my next guest says that Skakel's trial attorney, Mitch Sherman, also a guest on this program, bungled the case against Skakel, should in fact be free. The judge who vacated the guilty verdict 3 years ago ruled that Sherman didn't provide effective representation, but the state Supreme Court disagreed, saying Sherman, quote, performed competently. It was a 4-3 ruling. Norm Pattis, criminal defense attorney in Connecticut, also author of several books, including Taking Back the Courts. All right, what is the standard for adequate defense? Because at the heart of it, that's what the court had to say, which is maybe he didn't provide the best defense, but what he did was adequate.
The Sixth Amendment says you have a right to come. It means just some guy in a suit. It means somebody performing as counsel. So the question is, was Sherman's performance up to the standards of a minimally competent lawyer, or was it objectively unreasonable what he had done? If you can show that someone's deprived someone of the right to effective counsel, then you have to show prejudice, basically, that it mattered. So there are famous cases in Texas where a lawyer falls asleep in a capital case. The evidence is so overwhelming, the court says, yeah, well, you probably shouldn't sleep through the trial, but he was going to get convicted no matter what you did. In this case, the lower court held that many of Sherman's decisions were unsupportable, that no reasonable lawyer would behave in that way. The Supreme Court applied the standard, I think, correctly, but resulting in an injustice. Sherman had strategic reasons for what he did. Those reasons probably have a lot of buyer's remorse attached to it, and anybody who's ever tried a case knows what it is to wake up the next morning saying, man, shoulda, woulda, coulda. And so it's reversed the lower court decision, and Skakel is due to return to prison at some point unless something changes.
Now, from a procedural thing, there was also interesting timing and math with this. Explain in layman's terms how this 4-3 ruling, when it came down, who did the majority opinion that will no longer be there, because it's weird in its own right.
It's the second time in 20 years that the Supreme Court has brought discredit upon itself by playing pocket pool. Basically, just as the new year was ending on the 30th, this decision was published. The majority of the author of the majority opinion retired hours after the decision was rendered. It's a 4-3 decision. So he was very emphatic. He had to have insisted that this case be published before he left, because if you look at the state website, the case isn't even published yet. And by convention, decisions aren't published until the parties have had a chance to look at them. So somebody bent the rules to rush this decision in by the 5 o'clock deadline. Now, Mr. Sherman's lawyer is going to ask for a motion to reconsider. It'll go to the court. It doesn't require a majority decision. Now, at a 3-3,
Mr. Skakel's.
I'm sorry, I apologize. At a 3-3 decision, the decision will stand. There'll be no time to get a new justice in the next 10 days. But the rules of court may permit an appellate court justice to come up to the Supreme Court to what's called sit by designation. Well, who's that going to be? If it's a defense-oriented judge, things could look very good for Mr. Skakel. If it's a prosecution-oriented judge, likewise, or otherwise. So, I mean, it's unseemly, and I don't know what's going to happen.
I'll strip the veneer off. Mitch Sherman was a guest on this program and many other TV shows many times. Clearly, he was known as a show pony. Right. There was never a camera he didn't like. By all accounts, he could have put on a better defense. There are people who said he left a lot of clear strategic things on the table. At the time, when they said, no, we're going to kick you, Skakel, because you didn't get an adequate defense, do you think they got it right at that time?
As a practical matter and a human being, yes. I think that Mr. Kennedy's, Robert Kennedy is right. There are ample reasons to doubt that he committed the crime. So as a human being, yes. As a lawyer, no, because the legal standard is what it is. And you know, this case illustrates the tragic character, in my view, of the criminal law. Sometimes we have rules that arise to deal with the generality of cases, and as applied, they sometimes get it wrong. So I thought the lower court was moved by a sense of justice rather than a sense of law. The high court was governed by law rather than justice, and the result is right now an injustice.
Well,
Look,
I've got 5 attorneys here, and what I want to ask, Mark, is all of you.
There's a presumption that counsel performs reasonably and competently. That's the baseline presumption, and the burden falls to the defendant, rightly or wrongly, to overcome that presumption. As my colleague said, this isn't even a close legal call, but for the name attached to the case. This is run-of-the-mill stuff that's brought via post-conviction motion all the time. He has a prominent relative with a famous last name that's attaching it to a book that may well be right on the facts, but as a matter of law, to overturn a conviction based on something like this, if you're not a Skakel or a Kennedy, we all do this for a living, forget about it.
But I'm asking a more broad question, which is, from a practical level, the audience at home says, you know what, it's a lot easier to bring a malpractice case against a doctor, right, than it is to say that my attorney didn't provide, qualified defense for me. To that end, I'm asking you to put names to them. Do you think, by and large, there is legal malpractice, and I'm using that in quotes here, far more than there needs to be, and that their clients deserved much better counsel than they got, and as a consequence, this should happen more often? That they got unqualified defense and that they should at least be benefited a retrial? Is it too hard to get a retrial because of the defense?
I don't think people realize how difficult it is to competently represent somebody with all the forces that are against you. And lawyers work very hard and are second-guessed constantly by everybody.
And some do.
And even when a lawyer does something good, they'll say he didn't do it well enough. So the whole idea of lawyers running around doing poor jobs is a complete fiction. It happens. And when you hear a story of a guy falling asleep during a trial, we can all agree you shouldn't do that. But generally speaking, lawyers that I've worked with are very hard-working, competent people that take their jobs very seriously. And to just kind of throw around like that people are doing things wrong.
But you guys have handled cases on appeals. I hear you, Doug. But you guys have gotten appeals. And you'll look at the original attorney who represented your defendant and say, what was this guy smoking?
There's no question that happens. It just doesn't happen as frequently as you think. What does happen frequently is any one of us will look at the way a case was tried and disagree with the strategy and say, I would have done it differently, I would have done this, I would have done that. It just doesn't make it ineffective. It is difficult to develop your strategy during the trial. And you have to make,
too.
and very fast. You have to make certain on-the-spot strategic decisions. There are some times when, there's evidence that may look like it may benefit you, but there's also a downside to it. You may have a witness that's willing to testify in a way that helps your defendant, only when you find out that the cross-examination of this witness could sink the whole case. And then it's easy to say later, why didn't you call my alibi witness? Why didn't you call this witness?
And Jim, if you don't call the alibi witness, then it's almost per se it's going to be malpractice against you, because they're going to say, why didn't you put that person on? Well, maybe you're the only one who knows that person would perjure themselves. So it seems like, to all of us looking from the outside, to Doug's point, it seems like a clear malpractice for you not to have done something, but we don't know all of the other considerations that went into the decisions. And sometimes when the decisions work out, you look like a genius. If they don't work out, then it's the opposite.
But
it's very
to Rich's point, it's really overly difficult to establish
because people don't want to let a guilty defendant go free because the lawyer made a mistake. If it was just money at issue, that would be a different story. But
also,
perversely,
you look at who we're dealing with, and if you're looking at the cases, in the homicide case, I believe in Texas, where the lawyer fell asleep, and I believe maybe had never tried a case before, if I'm not mistaken.
If it was a Skakel
and then they
case,
find that is fine, that's harmless error. So there are a host of cases where clearly it is ineffective assistance, but the courts decline to find it being such.
Before I run out of time on this one, Norman, and we've had everyone from the Moxley family to Bobby Kennedy to Mitch, everybody that was involved in this over the years. The part of this case that has always been, to me, the biggest red flag, and by no means do I want to be a defender for Michael Skakel, is he was 15 at the time when he committed the crime. If he was prosecuted at the time, that he allegedly committed the crime. He would have been treated as a minor.
Right.
They never brought the case till he was an adult, but he still committed it when he was a minor. And he's being treated legally, and always has been, as he was an adult, even though he was a minor when he committed the crime. That, to me, was completely nonsensical.
Well, it is nonsensical. However, the courts in Connecticut have always had the discretion to transfer a serious case for somebody who's at the cusp of maturity or adulthood to a high court, to adult court, and that's what happened in this case.
That had to be a point on the original appeal.
And it was, that has been litigated all the way to the United States Supreme Court. I mean, we all know the emerging literature on maturation of brains, and a 15-year-old didn't know there. I mean, Skakel clearly wasn't sitting up in the tree doing whatever he was doing, you know. The fact of the matter is that if you commit a bad enough crime, you're going to get in front of an adult jury, and he did. Now, he was lucky in some respects, because at that time, Connecticut has what New York has, indeterminate sentencing.
Right.
He got 20 to life. Today, he would have pulled every bit of 60 years flat for that. So, you know, he caught a bad break in some respects, but a good break in others.
Norm, finally, do you believe, A, he will go back behind the prison wall, Michael Skakel, that is, and do you believe that he will get a retrial? I mean, some of it is...
Yeah, I want to know that too. Does he get resentenced, or is the original sentence up in the air now?
No, the direction from the Supreme Court was to remand to the trial court to vacate its judgment in his favor on the habeas. So basically, he goes back to where he was. The question for his lawyer is, what do you do to keep him out on bond? From my perspective, as long as my client's on the street, I'm winning. So he's got several choices, and I believe he's going to do them simultaneously. He's got 90 days from the final judgment to ask for a writ of certiorari from the United States Supreme Court. I don't think a Connecticut court will give bond in that circumstance. However, he can also bring a separate kind of habeas corpus petition in the federal court, and I think a federal district judge is likely to grant bond there, and that process will take 3 to 5 years to play out. So I think that Skakel will not return to jail immediately if his lawyer makes the right moves, and I know Hubie Santos' lawyer is thinking these thoughts, so I'm sure he will.
It's a pleasure meeting you. Thank you very much. All right, coming up next, Donald Trump will appoint a Supreme Court justice. I can see my friend at the end already starting to nod here. But the other 100 judges he'll also choose could have an even bigger impact on the country. We'll explain.